An employer can terminate an employee simply for complaining a lot. That's not illegal. Where it's illegal is if an employee is complaining about something unlawful or illegal, like working conditions, harassment, hostile working conditions, or reporting a workplace injury. Retaliation is different than simply just complaining about everyday job duties or things that they just don't like at work. The most common complaints that an employee can make that are legally protected are complaints about harassment, hostile working conditions, unsafe working conditions, a workplace injury, or discrimination in a workplace, being singled out or targeted, treated differently than similarly situated employees. That's all protected activity, and an employer cannot retaliate against an employee for engaging in that protected activity. To legally qualify as retaliation, an employee must prove that they engaged in protected activity, that they disclosed or opposed something that they reasonably believed was unlawful employment activity, and then that the employer took adverse action against that employee, like a termination, demotion, stripped job duties, excessive scrutiny, unwarranted disciplinary action. And the substantial motivating reason for the employer taking that adverse action against that employee was because of what that employee complained about and disclosed and opposed. Retaliation laws protect all employees in the workplace, despite employment agreements, company size, or types of employers. All employees are protected from retaliation in the workplace. In California, we have the anti-retaliation laws under the California Labor Code. We also have anti-retaliation provisions under the Fair Employment and Housing Act. So if an employee reports what they believe is harassment or discrimination in the workplace, they are protected from retaliation. A complaint does not have to be formal or in writing to be protected under retaliation laws. However, documentation is great evidence if an employee is going to pursue a claim against the employer for retaliation. Timing does matter for a retaliation claim. We're looking for a causal connection, something to connect the dots between the protected activity and the adverse action. If an employee engages in protected activity and reports what they reasonably believe is unlawful activity in the workplace, and then shortly thereafter, they're subjected to adverse employment action, and we can show the connection between the two, that's how we pursue these claims. Some examples of retaliation that an employee might not initially recognize as retaliation is subtle things like changing your job duties, changing your schedule, demotion, excessive scrutiny, isolation, manipulation, intimidation, unwarranted disciplinary action. All of those are little signs that something bigger might happen, like a termination. It's a misconception for employees to think that if they weren't fired, it's not retaliation. There are other adverse employment actions that we look for, like a demotion or change in schedule, something that is signaling that the employer is pushing the employee out, that eventually the termination will happen. Employers will often make an excuse, try to justify a termination, and they put it in writing that it was performance-related, performance issues. And what they don't realize is that the employee still has a story. And if the employee can show that they engaged in protected activity, they made a complaint, they spoke up, and then shortly thereafter they're terminated, the employer thinks they're justified because no, it was a performance issue. It's going to take more than just saying an employee has a performance issue to defend a lawsuit. A retaliation complaint that really stuck with me involved an employee who was a high performer, working well beyond the hours that she should have been working for the employer because she cared so much about doing her job and doing her job well. And because she worked so many hours, she exhausted herself and got sick. And her medical provider said, you need a medical leave or you're going to kill yourself. And so this employee reluctantly, but did exhaust a protected medical leave of absence. And right upon her return from taking a medical leave of absence, she was terminated the day she was supposed to return to work. And we associated that protected medical leave and the adverse action, the termination, as retaliation. This employee worked so hard, dedicated her life to this employer, and then they fired her. And being able to stand up to that employer and say what you did was wrong was one of the most rewarding cases that we pursued, because it wasn't okay. That retaliation was illegal. One of the first cases that we took on in employment law involved a pregnancy discrimination case. And I think that's when I knew it was my calling to practice employment law, because I saw what took place in the workplace and how employers try to get away with discriminatory motives. Once I dove into that case and started advocating for this employee who simply just wanted a maternity leave, but then was demoted, her job duties were stripped away, she was replaced by a male, I knew we had to do something. We had to create change in the workplace. And this, for me, was so powerful, and it was something that I knew I needed to do. One thing I wish every employee knew before they file a complaint at work is to put the complaint in writing. Oftentimes, if they do it verbally, the employer's going to say, I didn't know that. That never happened. And so I wish employees knew to document everything. That way, if something adverse does happen after they make a complaint, we have the paper trail and the evidence to prove that it was related to the complaint. If an employee feels like retaliation is starting, start documenting everything. Keep a journal, write notes, daily log of what's transpiring. Talk to HR, put your complaint in writing, and make sure that you're also communicating with your coworkers, because witness support is very important when we're pursuing an employment law claim against an employer. Documentation is very important when we're pursuing an employment law claim for retaliation. An employee should be documenting dates, what's happening, what's being said, quotes, get names, whatever you need to support your claims, because in real time you have an advantage of understanding and transcribing what's taking place. Employees can wait to see if they need to get legal advice if they're still employed. They don't have to call an attorney right away. However, attorneys are in the best situation to kind of guide the employee through what they're experiencing in real time. If they haven't been terminated yet, there might not be anything that the employment law attorney can do, but it's good to just seek advice and ask a professional on what they think they should do if they're in a situation where they're reporting illegal or unlawful conduct and they feel like retaliation might be ripening in the workplace. An employee should exhaust their internal remedies, meaning they should go to HR and talk about their complaints and try to seek remedial action or corrective action. If they're terminated, they should immediately contact an employment law attorney. For an employee that's listening and feels like they're in this exact moment right now that they're a victim of retaliation, hang in there. Tell your story, gain the courage. There will be a silver lining. Something better is out there. And at the very least, if you tell your story and hold them accountable, you did something. You stood up for yourself, and you should be proud of yourself for that.